And on Radio 97, it's time to talk law. Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, with us each and every Thursday after 8:30. Along with her legal expertise, she provides some general advice on the latest of hot topics. She's got experience that spans more than 25 years, count them, in the area of property and commercial law. She also prepares wills as part of estate planning and litigation. She joins us once again. Morning, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning, Despina. Welcome to the show once again. And this morning, to start off, we're going to be talking about something else that has hit headlines recently: sunset dates and clauses. It sounds so lovely, but it really isn't. It's caused a few issues, especially around Queensland, Despina. Why is that?
Well, yes, it has. And I'd like to talk about it and clarify some things for people out there who may be listening. We work with a lot of developers and we work with a lot of buyers in buying off the plan. And we do understand it really, really well. It's one of our areas of expertise. And we have seen a tremendous amount of off the plan contracts through 2021 and this year continuing. There are a lot of projects on the Gold Coast. I think this is quite pertinent to talk about it. And there's been some recent cases that have hit the headlines of buyers who have missed out on their dream lot that they went under contract for, say, 12 months ago or 18 months ago. And what the developer in those cases, as it's been reported, is that the developer has utilised what is commonly known as the sunset date and what is known under legislation, and has used that to say, look, we haven't completed the project or we can't sell you the lot completed by the sunset date that we put in our contract to you from the beginning. We're terminating the contract. So there's been a lot of uproar with some of these projects, not all, some of the ones where buyers have gone under contract early on, say young couples who were buying land that was to be subdivided to build their new home. And they come to the end of, say, the 12 or 18 months thinking that they're going to be settling soon, and the developers pulled the pin, terminated the contract for a variety of reasons. But particularly they've used that sunset clause to say, we haven't finished, we're terminating. I think the issue from these headlines that have been recently published is that some of the buyers are saying, well, are the developers really doing this to resell the lots for a higher price because the market is so buoyant?
Mm-hmm.
Of course, yeah. Especially in the past 12 months or 2 years because of COVID. You can imagine maybe if someone signed prior to COVID, the hike that property would have had. It's not the right thing to do, but if it's in the contract, it can be done.
Well, that's right. So we want to talk about how sunset dates work. And there was some of the articles that I read published some incorrect information in there. And I want to clarify that for people out there listening, in that there was some talk or conjecture that the sunset dates are just an arbitrary date and it's not really legislated properly to be included in these off-the-plan contracts, but that's entirely incorrect. So we want to talk about how they work and why they have to be and are in off-the-plan contracts. So at a very basic level, off-the-plan contracts, meaning, I'm sure everybody realises what that is, but what you're doing is an off-the-plan contract. The terminology means that you're buying something sight unseen, meaning you're buying something that is yet to be built, yet to be completed. The developer is doing a project where they might be building townhouses, they might be doing a land subdivision, they might be building a high-rise, but it's just only very early days. They may not have even broken ground in this piece of land that they bought, but there's a lot of marketing material. They've put out a lot of information about what they propose to build, and then people buy early on in the project, pay their 10% deposit typically, and then sit around and wait until the developer completes the project. Now, every off-the-plan contract in Queensland, and in other states as well, must have what we call and what is called in the Act, it must have a sunset date. And it's a date that the developer must disclose to the buyer in each buyer contract. So every contract that they sell a proposed lot to, each contract has a sunset date. And the sunset date is a date that not only has to be disclosed by law in the contract to buyers, but it also is a date that the developer must choose that applies to their project. So to put it in perspective, in Queensland, there's a maximum period of 5.5 years that is given by the legislation under the Body Corporate and Community Management Act, where you're buying lots to be developed in a body corporate. So first of all, a developer can choose a date up to 5.5 years from the contract date, and that's the maximum period allowed at law in Queensland. But often developers may choose a lesser date, for example, 3 years, 3.5 years, 4 years. It's entirely up to the developer what date they choose and what they think will be relevant for them. But rest assured that every developer must disclose it in their contract first of all. So, and if they don't, then it's not a proper compliant contract by law. But these sunset dates have been causing a few problems and concerns for buyers of recently. But the other reason that sunset dates typically have to be in there is these projects that developers undertake, there are commercial risks for long-term projects, as you can appreciate. So they are there to protect both buyer and seller in case the project can't be completed and the buyer is able to get out of a contract by the sunset date and get their deposit back. So the recent headlines about developers using these in the way that perhaps they shouldn't be, in that the market has grown considerably in the value of properties, and there's been talk and conjecture that developers are using these to simply terminate to be able to resell at a higher price, not because they can't complete the project, not because they haven't got any construction funding or for any other commercial reason that would be allowed under the contract. So that's what I wanted to raise this morning to talk about. Well, we might see some changes in Queensland in the near future, which I wanted to put out there, which the Attorney General in Queensland was talking about, Ms. Shannon Fentiman, which might mirror what happened in New South Wales. So a lot of people listening might remember a lot of the stories that came out in New South Wales with off-the-plan contracts over the last few years about how developers were doing just that, or some developers, where they were terminating specifically to resell at a higher price to profit more than what they should be. Mm-hmm. And then buyers that were under contract originally missed out, which wasn't really fair.
No.
Yeah. So then they changed the legislation in 2015. So in New South Wales, developers now just can't simply terminate a contract. They've got to get consent by the buyer to be able to do that by that sunset date. Or if the buyer doesn't consent, they've got to get a Supreme Court order. And that will involve the developer actually providing evidence to the court as to why they are looking to terminate the contract, which is very different to the Queensland position. And I think, given what's happened with the property market, I think that this may be something that will happen in the future for Queensland. And I think the changes might be pushed through by the Attorney General in the next year or so. We might see a similar position in Queensland to New South Wales.
All right, so
we'll have to wait and see.
That was 2015 that the changes were made in New South Wales. So that makes it 7 years ago. So Queensland still has a little bit of catching up to do, would you suggest?
It does. And look, like with everything, perhaps sometimes we are one of the last states to keep up with those changes that might be relevant. When we have changes like we have with the market, property growth, it hasn't been seen for years, and the ramifications and effects on off-the-plan projects like we have seen. And then it does raise, I suppose, concerns. Should we be looking at changing the legislation? Maybe we should, maybe we shouldn't. And I think it's a space to watch. But in off-the-plan contracts, buyers need to be aware that you must have a sunset date. Developers have to put that in anyway. It is up to the developer what date they choose in Queensland, but they can go up to 5.5 years. But the most important thing is you need to understand what that means for you as a buyer and the risks, because there's always risks in signing any contract, but you need to understand the nature of an off-the-plan, what that means for you individually as a buyer going into an off-the-plan, and you really need to get that advice up front.
For sure. Thank you, Despina. And coming up next, a common mistake that an agent may make. Beware, more details coming up on Talking Law just after this.